So, good day once again, guys. Welcome na naman sa isang video lesson dito sa Philippine Criminal Justice System. Okay, konting recap lang. The last video, we described thoroughly what the CJS is, Criminal Justice in the Philippines is, and we also defined its purpose. Tsaka we touched a little bit about law enforcement pillar ng kanyang purpose at saka purpose ng pillar at saka yung ano pa ba yung powers and functions and yung bonus organization tsaka yung iba't ibang examples ng law enforcement organizations or agencies. Now for today, meron tayong i-continue konti about law enforcement. And before anything else, I would like to apologize for the unnecessary background noise kasi nandito kasi ako sa office and merong mga students dito nag-enjoy sa kanilang concert. Okay, so tayo na lang mag-adjust. Okay? So, the police. So, ang police, in order to do his job, meron mga iba't ibang techniques at isa na dito isang patrol. A patrol is a proactive measure in policing. Proactive meaning kahit wala pang crime nangyayari, they are doing it. Hindi siya reactive. Reactive is yung mga steps na ginagawa ng isang organization kapag meron ng nangyayari. It is to react, to take action sa isang situation. So since this is proactive, so walang definite purpose, walang specific purpose yung pag-patrol nila. Specific in terms of merong crime na ina-address. Tuka sa King Tabi, grabe talaga yung background music dito. Okay, next sentence dito. The presence of uniformed police officers in an area deters an individual who plans to commit any violation of law. So, ang patrol is can prevent the occurrence of crime. It can deter an individual from committing a crime. Next definition is the police cannot satisfy the community in its services without patrol. It is the backbone of the police organization and the eyes and ears wherein police plans and actions are based upon. So, in all books made by different authors, they consider police patrol as the backbone of the police organization. Kasi dito sila nakakakuha ng mga information about the situation of the society. If there is need for reactive policing or not. And dito, they can, first-hand yung interaction with the community sa mga tao. So, it has a positive effect, especially in the PCR, Police Community Relations. Next definition is patrol is the bridge in establishing a better relation of the police and the community. Sa sinasabi ko, towards one common goal which is busting crime and keeping peace and order. Now, previously, nasabi natin na the police cannot work alone. Dapat cooperative effort ito siya ng community at saka ng police. Kaso lang, yung police is full-time yung trabaho niya. Crime fighting is everybody's is everybody's ano ba yung word? Is everybody's concern. Hindi lang sa police. Okay? So, next slide. One major purpose of police patrol is crime detection, which is indispensable to establish an effective crime prevention program. Next is in ordinary situations, crime occurrence may arrive to the attention of the police through the following. So first is citizens' complaints or calls for police assistance. Ito yung mga different um, different cases kung paano makakarating yung yung attention ng isang sa police. Attention ng police kung paano makuha. First is citizens' complaints or calls for police assistance. Merong magsusumbong sa police na, "Sir, na ay crime na hitabo dito," or na, "Sir, gisumbag ko ani ni ana." Okay? Next is observations and or inspections by patrol officers. Now, this is done through police police patrol. So, pagpatrolya from different areas, especially in yung mga areas na maraming establishments because they are prone to property crimes. Next is transmitted signals via activation of alarm devices. Now, ano to? Self-explanatory. Note, the determining factor for the resolution of reported crimes would be the time that elapses between acknowledgement of the information regarding the crime or incident and the arrival of the responding officers at the crime scene. In police terms, the principle is that shorter the response time, the better. Now, this talks about yung sa pag-act ng police. For instance, merong hit and run. So how fast can the police respond in the crime scene? Or merong hostage taking or merong robbery na nagaganap. So how fast can they act or arrive at the scene? So this is a factor to determine the efficiency of the police in that area. Okay? Next slide, crime prevention. Now, this is a method of anticipation, yung parang advance ka mag-isip, recognition, recognizing, and the appraisal of a crime risk and the initiation of action to preclude or impede its occurrence. Now, this is a technique in order to prevent or deter or lessen the occurrence of crime in that area. So, appraisal. So, you are going to judge or decide if that certain place is crime risk or not. Kasi kung hindi naman siya crime risk, so hindi dapat masyadong concentrated yung patrolling mo dun or yung mga crime prevention activities mo sa lugar na yon. Hindi dapat masyadong concentrated. Pero kung it is a high crime risk area, so dapat medyo focused doon. Okay? Next, purpose is to eliminate the opportunity of criminals to commit a crime. Now, this is true kasi sa crime triangle, which is composed of three elements, yung opportunity, instrumentation, and motive. Kung tatanggalan mo yan, hindi mabubuo yung crime triangle, which is hypothetically, crime triangle is the crime itself. So, kung tatanggalan mo yan ng opportunity, then yung matitira na lang is yung instrumentation at saka yung motive. So, hindi mabubuo kasi walang opportunity, walang chance na makakommit yung criminals ng crime. So, eto yung purpose ng crime prevention. Level of action in crime prevention. Now, the primary level of prevention focuses on passive measures like social awareness programs as an alternative in eliminating the root causes of crimes in the community. So, ano lang, police-community relations, to educate the people para hindi naman sila maging biktima. Okay? Or also to give them contact details para kung meron silang makita na kaduda-duda, so ma-actionan agad ng police. Okay, that is the primary level, yung social awareness. Secondary level of prevention is based on well-established law enforcement practices such as problem-oriented policing and hotspot analysis. Focuses on specific problems espoused with the goals of diminishing opportunities that increase tendencies for the commission of crime. So, ito yung pag-analyze mo kung ano yung mga lugar na maraming crimes na nangyayari. Okay? And then, you will act on it. Either instead of 10 lang yung police na magpapatrolya doon, pwede gawing 20 para just to lessen the opportunity of criminals to commit crimes. That is the secondary level. Okay, tertiary level of prevention is based on procedures that usually serve as deterrents, if not as a means of minimizing loss, damage, or hazards. Having insurance on personal injury and property, as well as employment of self-protective measures by previous crime victims are good examples. So, mga insurances, dito papasok yung mga insurances sa crime prevention. So, parang ano na lang, mga kasali dito yung mga fire alarm, burglary alarms, dito papasok. Okay? So, primary talks about informing the public, educating it. Secondary talks about yung problem-oriented policing, kung hahanapin mo kung ano yung posibleng solusyon sa isang lugar. And sa tertiary naman is yung pwede kang ng insurance or mga different kinds of alarms. Okay? Now, another responsibility of the police is to conduct investigation, crime investigation. Now, dito sa police investigation, it is considered as a second line of defense against crime. Yung first line kasi is yung patrol, crime prevention. Now, dito, it aims to identify the identity of the person who committed the crime and its location. So, identity ng person, ng criminal, ng perpetrator, at saka ang kanyang location. First thing the investigator should do is to determine if a law has been violated. Of course, yan naman talaga. So, he is going to analyze if meron bang na-violate, and then he will then know kung sino yung violator. After knowing, the investigator must know 1H and 5Ws. So, ano yung 1H? How? Yung 5Ws, what, when, where, who, why. Okay? So, eto yung mga questions na dapat ma-provide ng isang investigator upang ma-complete yung kanyang investigation. Okay, so ano nga uli yun? The investigator must know first na merong bang crime na commit. At saka, he must then answer the 1H and 5Ws. Sa joke pa lang sa mga police, 1 husband and 5 wives. Well, I hope you will not adopt that kind of mentality, okay? Dapat tig-isa lang tayo. Next is tools of investigation. Now, these are the tools. So, what are tools? Tools ay ito yung mga things na ginagamit natin. So, these are the things that we use in conducting an investigation. Now, this is also known as the 3 I's of investigation. First is information, interrogation, then instrumentation. Information, or which is also done through interview, is the gathering of testimonies from witnesses and victims. So, we can get information that hoping na meron tayong lead kung in cases like in situations na hindi natin alam kung sino yung gumawa ng krimen at yung location ng ng kriminal. Next is interrogation. It is the questioning of the suspects to obtain further facts. So dito na um, medyo ano na the person being interrogated is not free to what we call this free to go, parang temporary detained siya, detained. He is being questioned and uh, technically, logically, parang same lang yung information tsaka interrogation. Parang you are questioning people. Pero sa lang, sa information, you are not yet treated as a suspect. Sa interrogation, you can be detained or you are detained because you are a suspect. Okay? Now, instrumentation. Next is instrumentation. It is the application of forensic sciences to obtain physical evidences through a thorough crime scene processing by the investigator or with the aid of PNP scene of the crime operatives, which would help in proving the guilt of the person who violates the law. So, instrumentation is the use of different instruments. So, ano yung instruments ng isang investigator? Of course, dito na papasok yung criminalistics, yung polygraphy, photography, legal medicine, tsaka yung iba pa. Okay? So, what is the purpose? The purpose here is to keep a record na pwede nating i-present sa court as evidence to prove the guilt of the suspect. Okay? So, bali yung trabaho ng police is maghanap ng ebidensya. Okay, against sa tao na suspected of committing a crime. Note, an investigating officer is responsible primarily in taking care of injured persons, arrest or pursue suspects, protect the crime scene, and the physical evidence may be found therein. So, ang dami niyang responsibilities yung isang investigator, no? Of course, hindi naman pwedeng pabayaan yung tao, yung biktima, kaya nga it is part of his duty. Okay, next is, if a person is under custodial investigation, his constitutional rights must be protected, ensured, and respected. This is a part of the due process of law. So kahit na detained yung isang tao under custodial investigation siya, even if he is already being interrogated, hindi dapat ma-violate yung kanyang mga rights. Okay? So, teka lang muna. Now, next, rights of persons under investigation. Now, dito, ito yung mga rights ng isang suspect. Actually, rights of suspects. First is to inform of his rights to remain silent, to have a competent and independent counsel, preferably of his own choice or to be provided by kapag hindi niya offered. And right against the use of torture, force, violence, threat, intimidation, or any other means which violates the free will. Next is right against being held in secret, solitary, incomunicado, or other similar forms of detention. So dito sa first right, dapat inform siya na may right siya na to remain silent kasi anything he is going to say or do will be used against him in court. So, ito, para ma-protect ang mga self-incriminatory statements. Ito yung mga statements na that can put him into into deeper situations. So, to have a competent and independent counsel. So, dapat meron siyang abogado, lawyer. Right against the use of torture. So, dapat hindi siya pwedeng i-torture or any means na maka-violate sa kanyang free will. Okay, so hindi siya pwedeng porsahin na paaminin na siya talaga yung gumawa ng krimen. So, and the right against being held in secret, solitary, incommunicado. So, hindi siya pwedeng itago na hindi na siya pwedeng bisitahin. Meron pa ring right yung isang suspect na bisitahin ng kanyang pamilya or anyone na or guardian or loved one. Okay? Acquisition of information. Now, ibang topic na naman ito. So, pag-acquire ng information. Information gathering is done initially through interviewing of witnesses and victims. So, sa first eye, yung interview. Testimonies will be considered as leads. These are evidences that points to a possible solution. How the crime was committed, the identity of the criminal, and or location of the criminal. Now, hindi all the time na ma-apply talaga natin ito lahat kasi paano naman kung alam na natin yung identity. So, there is no further need to identify the identity of the criminal unless kung meron siyang ibang kasama. Okay? Next is entrapment and instigation. Now, this is also a technique of the police to in order to catch a criminal who is doing a crime. So either kidnapping or ano ba ito, drug selling na through poser buyer. So, ito yung mga different techniques. First is entrapment. Signifies the ways and means used by a peace officer to catch or apprehend a person who has committed a crime. With or without it, the crime has already been committed. So, entrapment, they are going to make a trap in which yung suspect is yung nag-instigate, nag-start, nagsisimula. Na kung merong entrapment or wala, meron talagang crime na nangyari. Instigation takes place when a peace officer induces a person. Siya yung naghikayat ng tao to commit a crime. Without it, the crime would not be committed. So dito, eto parang yung instigation is yung police o yung agent ng law ang nagsimula sa paggawa ng crime na kung if not because of the inducement, walang crime na mangyayari. Note, in instigation, the peace officer is liable as principal of the crime. This is an example of absolutory cause, thus, the arrested person is exempt from criminal liability, hindi siya makukulong, but not from civil liability. So, meron siyang pagbabayaran kung meron mga damages sa property at saka doon sa tao. Kung meron ba siyang na-violate na, let's say, rights ng isang tao or tungkol ba sa kanyang moral dignity. So, dito sa instigation, yung instigation is bawal. Entrapment is hindi. Sa instigation, yung police na nag-start and the police is liable. Pwedeng makukulong, pwedeng kasuhan yung police dito. Okay? So, for instance, yung isang tao, kahit na hindi siya nagbebenta o tumigil na siya sa pagbebenta ng droga, but, sinabi ng police, sige na, ibaligya. So, ibaligya, na in which case, kung wala tong police, wala untay crime. So, ang police pa ay nag-provide sa drugs o sa kwarta. Then, ayun, nangyari na yung krimen. Now, absolutory cause ito. Exempted sa imprisonment yung civilian na involved. Okay? Next is arrest. Now, isa din ito sa um, responsibility ng isang police to arrest a person suspected of committing a crime. Now, arrest is the taking of a person into custody. Custody is kung sino yung hawak in order that he may be bound to answer for the commission of an offense. So, kukunin mo yung tao para hawakan ng organization in order makasuhan siya para hindi na siya makawala. Okay? Now, there are two instances na pwedeng the police officer can make an arrest. First instance is a warrant. A warrant is issued by a court signed by a judge in effect of a criminal charge filed against a person. So, yung warrant is i-apply mo pa, i-present mo pa sa sa korte. Okay, you are going to file a complaint to the prosecutor, then the prosecutor will forward it to the judge. If the judge may nakita yung judge to na probable cause, then that's the time na pwede na mag-issue ng warrant yung judge. Okay? A warrant is always signed by a judge. Tapos dapat nandun yung kung sino yung tao na na i-aaresto at saka yung crime na kanyang na-commit. So, dapat kompleto na yung information sa warrant of arrest. Second instance, no warrant and on the following situations. So, wala raw warrant of arrest. First situation is when in his presence, the person to be arrested has committed an offense, is actually committing or attempting to commit an offense. So, gumagawa ng krimen, nakagawa ng krimen, gumagawa ng krimen, or gagawa ng krimen. Okay? Next situation is when an offense has in fact just been committed and yung arresting officer has personal knowledge of the facts, indicating that the person to be arrested has committed a crime. So, dito sa second situation is meron siyang personal knowledge. Third is when the person to be arrested is a prisoner who escaped from a penal institution or place where he is serving final judgment or temporarily confined while his case is pending, or he has escaped while being transferred from one confinement to another. So, escaping. Okay? Dito sa first situation, this is in flagrante delicto. Second is hot pursuit. Third is escapee. Okay? So, dito sa second instance, pwede ding ma-apply dito yung citizen's arrest. Okay? So, paano ba gagawin yung citizen's arrest? You are going to arrest that person, inform him that he has committed a crime, and then you are going to temporarily detain him, then forward it to the authorities. Okay? Dapat klaro yung mga ebidensya para hindi maging liable yung citizen na nag-aresto. Okay. After the arrest, the person arrested shall be informed of his constitutional rights. So, this must be always done at all times or else void yung pag-aresto mo. Now, may mga technicalities dito. Okay? Kapag na-violate mong kanyang constitutional rights. So, first is his right to remain silent. Second is his right to be informed of the nature and cause of the arrest. I-inform siya na kung ano yung nagawa niya. Third is his right to have a counsel of his own choice. So dapat dapat ipapaalam mo sa kanya na meron siyang karapatan na magkaroon ng abogado. Kung hindi niya ma-afford, bibigyan siya. Okay? The person arrested without a warrant shall be detained subject to the hours prescribed under Executive Order 272. So, sa second instance, yung first instance is merong warrant yon. So, sa second instance, kapag less than 24 hours, nahuli yung taong nakakommit, inquest proceeding yon. Ang tawag doon, inquest. So, may time frame na dapat may number of hours na pwede lang siyang i-detain. So, in that time frame, in that period of time, dapat makapaghain ka na ng kaso. Now, for light offenses, 12 hours. For correctional offenses, 18 hours. And for afflictive offenses, 36 hours. Note, the hours of detention will only be counted during government office hours, which do not include breaks, holidays, and the like. If the hours of detention had already elapsed and no case has been filed in court, the detained person must be released. Otherwise, the police could be charged for arbitrary detention. So, eto yung liability ng police. Kapag hindi niya pinalabas at saka lumampas na sa prescribed number of hours na pwede lang siyang ma-detain, tapos hindi pinalaya, well, pwede makasuhan ng arbitrary detention. Now, within the time frame, dapat makapaghain na sila ng case. Nakasabin na sila doon sa prosecutor. Okay? So, next is bail. Now, bail only applies to those who were, yung mga taong na nasampahan na ng kaso. Now, what is bail? It is a security given for the release of a person in custody of the law, in which case, the custody of the police, provided that he is not charged with a crime whose punishment is death. So, bail only applies to those who yung crime na nagawa niya is not punishable by death and is not punishable by reclusion perpetua or life sentence. And if the evidence of his guilt is not strong. So, bail, parang security ito, parang collateral ng isang suspected person na gumagawa ng crime for his temporary release until ma-acquit yung kaso niya. Okay? So, here are the different types of bail. First is corporate surety. Corporate surety is a private institution guaranteeing the appearance of the person whenever the court requires. So, isa itong private institution na maggarantiya na etong taong ito, we will provide for his bail, and then in time na tatawagin yung yung suspect for a hearing by the judge, so the private institution will do all of its efforts na maka-appear siya sa court. Okay, next is property bond. Covers only real properties that would guarantee for his temporary release. So, eto na yung pwedeng gawing piyansa ang mga kontrata sa yuta. Okay? Titulo, land titles. So, land titles lang ang pwede dito sa property. Okay, next is cash deposits. Pera is the amount recommended by the prosecutor and may be changed or fixed by the judge and must be satisfied by the bondsman. So, yung prosecutor yung mag-suggest kung magkano yung piyansa. And nasa judge ang final decision kung magkano yung pwede na amount na magiging piyansa ng isang suspect. Accused na pala siya dito. Okay, next is recognizance. Recognizance is done by a responsible and reputable person in the community, and he has the obligation and responsibility for the release and present him whenever the court needs his personal appearance. So, for instance, mayor, if sasabihin ng mayor, okay, I will make sure na pag may hearing at nag-order yung judge na mag-appear yung accused, yung suspect, yung accused sa korte, then so, he will do so. Parang kung sa Bisaya pa, ako'y bahala. Ayaw kabalaka, mutungha lagi ni siya sa korte. So, by using his word as a responsible and a reputable person, pwede siyang siya ang liable kapag tatakas yung akusado. So who is qualified to make a bail through recognizance? Example, mayor, congressman, okay, at iba pa. So moving on. So this is another duty or responsibility of the police officer. Search and seizure. Search is yung paghahanap. Seizure is yung pagkuha. So ano yung kukunin? Of course, mga material, mga physical evidences. And this is the taking of physical evidences that will establish guilt of an offender through a legal and valid search. This is done through a search warrant. So, sa paraang ng pagkuha ng search warrant. So, doon sa search warrant, naka-indicate din doon kung ano yung gamit na kukunin. Dapat kompleto ano ang gamit na na kanilang i-seize, and ano yung location. Now, search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer, commanding him to search for personal properties described therein and bring it before the court. Now, order ito ng isang korte na kukunin itong bagay na ito, which is a physical evidence that can prove or support the guilt of an accused. Okay, so this is an order commanding a police officer to search for personal properties, or even if it's not personal, basta it has a connection to the crime. Now, property to be searched and seized. First, property subject of the offense, property stolen or proceeds or fruits of the offense, things which are used or intended to be used as a means of committing an offense. For example, sa una, subject of the offense, let's say, drugs. What you call this? Yung meron kang drugs, yung nagdadala ka ng drugs, ano ba yon? Possession. possessing drugs, so you are committing a violation against the law. So that possession, that drugs is the subject of the offense. Now, property stolen or proceeds or fruit of the offense. So, nagiging part din ito sa kaso. Let's say, motorsiklo. So, kailangan talaga na i-seize yung, yung gamit na naging part sa isang kaso. Okay? Kung motor, of course, picture lang yung i-present doon sa korte. Pero yung custody, yung kung sino maghawak ng ano ng physical evidence na yon is ang korte. Okay? So, since it is a part, dapat din i-seize yun. Okay? Now, third is things which are used or intended to be used as a means of committing an offense. So, let's say a knife, a hammer. So, it was used to commit an offense. Okay? In which, hindi siya subject of the offense. Kasi, mere possession, you are not violating a crime. So, naging tool lang siya sa pagpatay or sa pag-harm ng ibang tao. Now, a search warrant may be secured by the police upon filing a complaint affidavit and testimony of the witnesses duly subscribed and sworn, and filed it before the court judge indicating that the crime has been committed. The judge will then determine the affidavit of complaint and the witnesses whether there is sufficient ground to believe that a law has been violated. So, yung search warrant, ina-apply yon. Pinapasa yon sa korte. Then, ang judge yung mag-decide kung if he is going to order the police to search and seize the following items involved in the violation of a crime. Okay? Now, I think that is the last part na dun sa mga yung medyo involved pa yung law enforcement pillar. Now, next would be the prosecution pillar. So, what is prosecution? It is the process or method whereby accusations are brought before the court of justice to determine the guilt or innocence of the accused. So, sila yung mag-a-accuse. So, accusations are brought before the court of justice. So, dito sa court nangyayari yung trial, yung hearing. So, yung mga lahat ng accusations na ginagawa sa korte during the hearing, yan yung prosecution. So, ang trabaho ng prosecution is to accuse you, to accuse the accused, na dating suspect. Okay? Accused is also considered as defendant because they are going to defend themselves na, hindi ako ang gumawa ng krimen na yan. Pero yung prosecution ang nagbibigay ng mga ebidensya, ikaw yun gahimo ani, ikaw yun ang nang-rape na ako ebidensya, ana. So that whole process is prosecution. Now, who does this? It is the prosecutor. A person who is a quasi-judicial officer who assumes full discretion and control over a criminal case in the administration of justice and represent. So, representative siya, represent the government or the people of the Philippines in a criminal proceedings in the court of law. So, kapag na-violate lang yung laws ng Philippines, which was represented by the senators, yung prosecutor yung magre-represent. Okay? So, next is approaches of prosecution system to better understand kung ano itong prosecution. First approach is adversarial or accusatorial, from the word accuse. The victim or his representative have the primary responsibility for finding and presenting evidence to the court. The judge listens to the accusation and determines the applicable punishment to the accused. So sa accusatorial, ginaakusahan na siya. So this is meron justice system dati na accusatorial in which you are not considered innocent. Kina-accuse ka ikaw gabuhat mo na, then kina-present ang mga ebidensya. Okay? Dito na naman sa inquisitorial, the judge searches the facts, listens to witnesses, and investigate to prove the guilt or innocence of the accused. Sa inquisitorial system, you are considered innocent. Hindi ka pa inaakusahan. Ano lang, you are being, parang interrogated or investigated lang. Okay? So, dito, yung judge yung magsisilbing decision maker kung ikaw ba ay isang inosente or ikaw ba yung gumawa ng krimen. Now, yung Pilipinas ang nag-adapt ng mixed system, accusatorial at saka inquisitorial. Okay? Adopts both inquisitorial and accusatorial, where the victim or his representative provides the facts, evidence, and testimony of witnesses to prove the guilt of the accused. The judge will then investigate and determine the guilt of the accused beyond reasonable doubt and its moral certainty. The mixed approach is used and applied in the Philippines. Mixed ito in terms of yung sa relationship ng prosecution at saka yung court. Kasi we are talking about sa justice system natin ha. Mixed system yung justice system natin. Accusatorial yung prosecution. Siya yung nagbibigay talaga ng ng mga ebidensya na ikaw you're accused. Yung prosecutor is the one pointing the finger. Is the one pointing the blame of the commission of the crime to a person or persons. Ito naman yung judge. He adapts the inquisitorial system in which he is going to inquire, he is going to analyze, to search for evidences based on the evidences submitted by the prosecution and the other party. So he is going to analyze the evidences presented to him. Then he will then make a decision, a judicial decision kung guilty ba yung isang party or hindi. Okay? Now, the main function of state prosecutors is to investigate administrative charges against fiscals and other prosecution officers. He also conducts investigation and prosecution of all crimes. So, yung main function, isa sa kanyang main function is to provide checks and balances sa mga lower prosecutors kasi pwede namang maging pwedeng ma-abuse ng isang prosecutor yung kanyang power. Even if kulang yung ebidensya, even if walang probable cause, hindi klaro na merong crime na commit or siya ba talaga ang nag-commit, so mag-file pa rin siya ng case in which, let's say, kung maraming backlog yung judge, so hindi pa masyadong ma-attend ng judge yung case na final. But, i-safe keep na yung suspect. Madedetain na yung suspect. So, kahit inosente siya, kahit in the future ma-prove na inosente siya, maka-experience yung suspect ng detention. Makukulong siya temporarily habang hindi pa tapos yung kanyang kaso. So, it is a bit unfair, especially for those hindi maka-afford ng bail. Kaya nga, yung higher, what we call this, higher offices, eto sila yung mga mag-entertain na mga abuse of authority. Okay? Now, next is the main function of regional prosecutors. They exercise immediate administrative supervision over all provincial and city prosecutors. So, siya yung under sa kanya yung provincial and city prosecutors. So, kung meron din mga complaints, siya din yung mag-take action. Prosecute any case arising the region. So, sa regional level siya. Pero dito na naman sa provincial and city prosecutors, they are in charge with the prosecution of all crimes, misdemeanor, and violation of city or municipal ordinances. So, dito sa regional prosecutors, they are in charge. They prosecute cases na pang regional level yung kaso. Ano example? Sir, murder. Murder is sa regional trial court talaga yan. Hindi yan pwede sa provincial or sa city. Okay? Next is investigate and or cause to be investigated all charges of crimes, misdemeanors, and violations of all penal laws and ordinances. So, mga ordinansa, misdemeanors, and all violations, mga minor violations, sa yan? Sa provincial and city level. Okay? Purpose of Prosecution Pillar. First purpose is to screen para hindi masyadong marami yung aatupagin na mga cases ng sa court level. Determines, so by determining, parang screen na rin niya and decides which case would be filed in the courts and which of the cases shall be dropped. So in that process, hindi na makakalusot yung kulang ang ebidensya or kulang ang ebidensya na may crime na commit or kulang yung ebidensya na itong tao ito, yung suspect, siya ang nag-commit. Next purpose is to determine what crime should be charged against an offender. So dito pa lang dapat klaro na kung ano yung crime na pwedeng i-file sa kanya based on the evidences. Okay? Because it affects many things. It affects the bail amount. It affects if pwede ba mag-apply ng probation yung isang accused. It affects many things. Okay? Next is determines if the evidence scattered by the police meets the standard of proof for successful prosecution and conviction. So, enough ba yung evidences? In this precept, where the prosecutor is deemed to have more control over the life, liberty, and reputation of a person suspected to have been violated the law. So, dito pa lang, parang grabe ang whiteness ng authority ng isang prosecutor. Kasi nasa kanyang kamay, nasa kanyang discretion kung sino yung kung may may sapat na dahilan, if there is probable cause na na-file ng kaso yung isang suspect. Okay? Kasi kapag yung prosecutor ng isang lugar, kapag friend niya yung inaresto, pwedeng hindi siya mag-forward ng information. So, mapipilitan yung police na palayain yung nahuli nila. So, yung gagawin dapat ng police is pwede siyang, in that situation, pwede siyang No. Special occasions na ito, pwede siyang lumapit sa ibang prosecutor. Prosecution process. The prosecutor determines what court has jurisdiction over the offense committed. Crimes with imprisonment of 6 years and below, complainant may file to the court that has jurisdiction over it, such as municipal trial courts and municipal circuit trial courts, or to the prosecutor's office. So sa municipal, city, and provincial level lang ito. For offenses falling under the jurisdiction of the RTC or the regional trial court, such as rape, murder, homicide, or has a penalty above 6 years, the filing of complaint must be in the prosecutor's office for the purpose of conducting a preliminary investigation. Okay? Yung preliminary investigation is the search of probable cause. So, may investigation na gagawin yung prosecutor, titingnan niya kung meron bang um, katamtamang dahilan, reasonable cause na yung isang na may crime na na-commit at saka yung itong suspected na taong ito ang nag-commit. Okay? So, remember, 6 years and below, hindi sa RTC. Sa lower courts. Kapag above 6 years, automatic regional trial court. Now, dito kanina, kapag yung tao, sa second instance ito sa arrest, inquest is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether or not the said person should remain under custody and correspondingly be charged in court. So, maa-apply lang yung inquest or in this case, inquest proceeding kapag yung taong naaresto ay naaresto dahil hindi dahil sa warrant of arrest. Okay? So, may tatlong situations yon. First is in flagrante delicto. So, he is caught doing a crime, has just committed a crime. So, ano ito? Has just committed a crime, committing a crime, and about to commit a crime. So, second situation is hot pursuit. Yung arresting officer has personal knowledge na itong taong ito ang gumawa ng crime. Third is escapee. Okay? So, next, preliminary investigation is an inquiry or proceeding for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime cognizable by the RTC has been committed and that the respondent is probably guilty thereof and should be held for trial. So, eto yung ginagawa sa RTC lamang. So, nangyayari lang ito kapag yung crime is more than 6 years. Okay? So, ano ang hinahanap dito? Probable cause. Prima facie. It denotes evidences which, if unexplained or uncontradicted, is sufficient to sustain the proposition it supports or to establish the facts as to counterbalance the presumption of innocence to warrant a conviction. So, parang assumption ito. Let's say if you are caught possessing drugs, so it is assumed na gumagamit ka ng drugs or nagbebenta ka ng drugs. Unless, you are contradicted by the other party, by the defendant party. Moingon tong pikas na, possession na iyan ko ayn, kaya wala man niya ni gamit, then wala po siya na maligya. Okay? So, let's say another prima facie evidence is that um, a sachet of shabu was found in your car. So since it is your car and it is found in your car, it is then presumed by the law that you are the owner of the drugs. Parang ganon. That is prima facie evidence. Next is complaint. It is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer or public officer charged with the enforcement of the law violated. So dito sa complaint, ito yung ano, ito yung written statement. Sinulat ito sa papel na charging a person with an offense na itong si ganito, itong si Sir Tan ay naka-commit ng homicide. So, subscribe by the offended party. So, dapat nakaperma doon. Ano. So, it is a sworn written statement. So, saan ito i-forward? May mga cases na automatic sa judge, pero usually, kadalasan, diretso sa prosecutor's office. Okay? Sa prosecution. So, yung prosecutor, in this case, kapag makareceive siya ng complaint, either he will undergo preliminary investigation, yung hahanapin niya is yung probable cause. Sufficient reason based upon known facts to believe a crime has been committed or that certain property is connected with a crime. So, kapag may makikita ng prosecutor na meron talagang crime na commit at klaro yung mga ebidensya na itong tao to ang nakakommit na crime, then he is going to forward a piece of paper doon sa korte. It is called information. It is an accusation in writing charging a person with an offense subscribed by the fiscal or prosecutor and filed with the court. Okay? So, from there on, ang next na stage na trabaho ng prosecution is to prosecute criminal. He will make accusations, provide evidences, represent the people of the Philippines. Then, I think that's it. Diyan nagtatapos yung trabaho ng prosecutor. Okay? So, hopefully, I will be able to... hindi na pala. So, next meeting, which is this Wednesday, we are being, advised by the main campus na gumamit na ng MS Teams. So, hopefully na you all are familiar with MS Teams. So, see you soon. And by the way, hintay na lang kayo sa inyong midterm exams. So, I will not be hard on you since all of us are affected by this pandemic. Maraming naghihirap. Kami nga mga teachers naghihirap din. Especially sa load. So, sadly, we cannot do this anymore. Itong mga pre-recorded videos. But do not worry, I'll try my best na maka-provide din ng proper instruction sa inyo. Okay, so I think that's it. So, see you all until next time. Bye-bye.